of advantages because attorneys know what the court is going to look at in your document, especially when it comes to terms and time frames. Sometimes there's things that have to be done within a certain amount of time, and if you miss that deadline, it makes it complicated for your loved ones. What if I change my mind about something that I put in my will? That's fine. Just call your attorney ASAP and change it. Just because you executed a document doesn't mean you're stuck with it forever. And hopefully, if you're working with a good attorney, they're not going to charge you $1 million to make adjustments, because we know how important the document is to the rest of your life. Is it possible for me to leave something to someone in my will, but keep that person from giving it away or selling it to someone else? It actually is. You can put mild discretionary rules in a will. They're very, very vague because in order to be specific, you would have to get a trust, which I'll cover in my next presentation. But in the confines of a will, you can leave something to a person for their lifetime, and it's called a life estate. So if I say I give my home to my mother for life, she gets to keep that house, live in that house, have that house until she passes away. And I could even go so far as to say to my mother for life and then to my nephew. So how do I revoke a will? It's really as simple as tearing it up. You just want it to be known that others are aware that you don't want that document used. You can scratch it up, you can tear it up, you can burn it. Just don't have the original lying around intact. So what property does a will cover? So a will covers two types of property. So probate property is any property that's in your name solely or as a tenancy in common. And a tenancy in common is a legal term for a property that is yours individually. So if we own something together, but I had 50% tenancy in common and you have 50% tenancy in common, when I pass away, it goes to my children or whoever I want it to, and you have no rights to it, even though we split the percentage. It generally passes through probate, by will, or intestacy.
Okay, so if you have 50% and somebody else has 50%, you can only give your 50% away.
Yes.
Okay.
You own 100% of your 50%,
Okay.
if that makes sense. And then on the flip side, part of non-probate property is joint property, which is the opposite of that tenancy in common, which is a joint tenancy or a tenancy by the entirety. So a joint tenancy means we own it together, and it usually has a term that says it has survivorship, meaning if my brother and I owned a home in joint tenancy, when I pass away, my 50% goes to my brother and he owns 100% of it. And there's no legal signing, executing. It's just, if it's titled that way, that's what happens. And a tenancy by the entirety is the same thing, but it's only exclusively for married couples. So other types of non-probate property are life insurance, retirement benefits, payable on death accounts, transfer on death, and property and trusts. And I will cover all of those later in the presentation, except for trust. But that basically means that the court will not probate it. And probate is a very long and expensive process. So if you can avoid it, I would advise it. So what do you do if you do not have a will? So as I already covered, you'll be considered to have passed away intestate. And so why do people often pass away without making a will? There's plenty of reasons. Some people don't like the thought of death. They don't like facing their own mortality. They don't want to spend the money on an attorney or on a software to do it, or their time. Sometimes they just can't decide what they want, so they never really get around to doing it. So yeah, that's generally the most reasons why you see someone not making a will. And statistically, 70% of Americans do not have a will of any type. 70%. Yep. So what happens to your probate property without a will? So without a will, the court has its own set of default rules. So they would look to what the average person would want. So if you don't specify where you want things to go, the court is just going to say most people want their family in this order or that order, so that's what they're going to pick. So if you don't have a will and you die intestate, after probate, whatever's left over, the court will typically give it to your spouse, to your kids, and to your other relatives, which are collaterals like siblings, aunts, uncles, etc. But the interesting thing about it is you can never really predict where they're going to go first, depending on who's currently living. Mm-hmm.
Okay, I'm sorry.
No, go ahead.
So you said after probate.
Yes.
So during probate, so let's say you have $100,000 and you got like $60,000 in bills, like medical bills.
Mm-hmm.
If your stuff is in probate, that $60,000 has to be paid first.
Yes. So probate is basically the evaluation of your estate, of your debts, of your liabilities. Whenever you open a probate, you essentially give notice. You give notice to creditors, interested parties. I actually filed a probate today, which was one reason why I was running crazy at the courthouse. And I have to send documents to any known creditors of the person who passed away, any children, any spouses, regardless of if they put them in their will or not, because someone may contest the will. So everyone has to be notified.
So is there a way not to have to do probate? Or is probate just
Probate, you have to do it unless you make trust.
trust?
Yes.
And we'll talk about that later.
And that will be in the next module. Trusts are my favorite. I definitely think they are worth making. Yeah, go ahead.
So as far as probate is concerned, you mentioned the cost.
Yes.
Who pays that? So is it the person who died, is it their, whatever they have left, that's who pays it? Or are the people, family and children and stuff responsible for that?
Generally, all the funds for probate come from the decedent's estate. The sad thing is, usually, the majority of people that go through probate, it wasn't that they had a will, it was that they didn't. And so usually those funds are negated. By the time creditors get through, you end up paying attorneys or your debt falling on loved ones because you just didn't have enough funds and you were in debt of some sort. So
who's responsible for paying that? Like, let's say,
yeah,
I have $100,000, but I have $100,000 in debt, so all the creditors take what I have. Who pays the attorney's fees and court costs and so on and so forth?
if you hire an attorney, such as like, if it's your father and you hire an attorney, the attorneys get paid from the estate, and there is an order of priority that the court goes by. So creditors get paid first, and it also goes by how important the creditor is. This is the IRS, they're getting the money first. They're taking it, Other creditors, if they're notified and they don't say anything, they miss their window. So, and then of course, attorneys, usually in their documents, they have it signed that if there's not enough money in the estate, they will get their money prior to distributions, if any funds are left over. And it depends on the debt that's left over. Usually some things will just be waived because the person just passed away. You see that a lot with student loans. Sometimes it's just like, oh, they passed away. There's nothing really you can do about it. And you only really run into that problem when it's assets that people keep. So.
I think we have another question.
Uh-huh.
And this might be in the weeds. Because we talked about, like, if you own a house with someone else, but you only, let's say you only own 50% of that house.
Mm-hmm.
So those are your assets for only 50%. So if you die and don't have a will, is your 50% of that, like, will they have to buy your 50%? Or is your 50% going to go towards your creditors? Like, I know this is a lot.
So you're saying if you have a property that's joint, not in like individual interests, if you have a property with another person and their creditors are coming after that asset, if both of your names are on the title, that's kind of, they're going to be able to come after it. But there are certain stipulations with attorneys that you can put in to avoid that, and usually those come with trust. And there are things called spendthrift provisions and things like that I'll go into in my next module to try to insulate you from creditors.
But they could force you to sell.
Yeah, if you have a lien and there's debt. Of course. Okay, so what can your will not do? As I stated earlier, your will cannot avoid probate. It's just a part of having a will. It cannot direct what happens to any non-probate property. You cannot put certain conditions on gifts like you can do in a trust. For example, my daughter must be drug tested prior to receiving her inheritance. You can't do that in a will. It cannot arrange care for a beneficiary with special needs. It cannot have its information sealed away. It is a public document. The minute it is filed with the court, anyone can get on OSCN and see what's what. Your kids' addresses, phone numbers, etc. And it cannot reduce your estate taxes, which typically in a trust, there's methods of funding your income as it comes in and your trust grows and filtering it out to keep you from having to pay as much as you would with a will.
So whether you have a will or not, you have to go through.
Yes, unless you have a document that certifies it as non-probate property, which would be primarily number one is a trust, and then also these right here, the next slide, is how you avoid probate. So here are some documents. We're here, So the easiest way is what's called a revocable living trust, which I will go into in my next module because it has just as much depth, if not more, than a will and all the documents that a will comes with. Also, there's something called, so if you don't want to make a trust and you want to avoid probate at all costs, these are some things that you can do. So here's a thing called a transfer on death deed, and it's a legal instrument, and it's only for your home. And essentially, you sign a piece of paper that says, upon my death, so-and-so will get my property, and it just transfers. No fees, nothing. Yes?
Is it if there's no mortgage?
It depends on what you would like. You can put on there whether or not the person will take subject to the mortgage or whether the estate will pay off the mortgage prior to transfer. And then if you if you would like to utilize a transfer on death deed, please consult an attorney. It can honestly even be as easy as if you know one, just give them a phone call, don't make it too complicated, because there are timing requirements, such as there's a 9-month window. After the date of the individual's passing, you have 9 months to get that TODD to the court, or it's as if you never made it, and that asset's going to be probated. I don't know why they made it like that, they just did. The next thing is called a transfer on death affidavit, which is the exact same thing as for a house, it's just for vehicles. Mm-hmm.
So on the, and I'm sorry, on the transfer on death deed.
Mm-hmm.
So with that property then doesn't have to necessarily be accounted for in the deed, right?
No. Mm-mm. Usually you can utilize all of these methods without a will, but a good estate planning attorney will give you a will just as a fail-safe, as a backup, just in case if you miss that 9-month window and it has to be probated, at least it's going to go in the order that you prefer. And then there's also a payable on death designation, which is when you arrange with your bank or your credit unions that upon their passing, the name automatically transfers to who you want it to, and they have immediate access to those funds. And then, of course, I already kind of covered the joint tenancy with right of survivorship. Basically, two people own 50% jointly in an asset. Upon one person's passing, it automatically pours into the other individual. And then the tenancy by the entirety is for married couples. And then life insurance and retirement benefits, those don't go through probate. You just want to designate a beneficiary.
So on, so for married couples, you said there's a tendency by
The entirety.
Is that, so if there is no will and one spouse passes away, did that, I mean, that is intact and it goes,
Essentially, you're gonna want to have both names on the piece of property,
so as long as both names are
such as your house or something like that. Yes.
So what if you get the life insurance and retirement benefits? What if you don't have a designee, or just so happens the designee happens to be with you and you both pass away at the same time? What happens?
You're going to want to have a backup beneficiary. They're always going to make you do a first and a second. And then if you have a policy and the individual is not living, I'm actually not 100% sure on what happens with the life insurance because, what'd you say? Succession, yeah. They're going to just put it in an order. That would be an insurance law question. But that's a great question. And then I will cover some ancillary documents, which basically ancillary is just kind of in addition to. These aren't for probate or avoiding probate, but any good attorney would kind of just like loop these in the box just so you have everything done in one fell swoop. These are planning for incapacity or death. And so you would want to make an advance directive. It's also called a directive to a physician or a living will. And it basically declares your wishes with respect to your life-prolonging treatments and your organs. So if you end up in a vegetative state, do you want nutrition and medicine? Do you want one or the other? Do you want neither? There's little boxes that you can check. One thing that I would recommend is when you get the form from an attorney or from online, wherever you receive it, take it home and read it and sleep on it and read it again. You don't want to just go checking random boxes because you feel like you need to speed through it. And then there is a durable power of attorney for property. So this allows you to name who you want to make your decisions regarding your finances and your property. And then there's a durable power of attorney for healthcare who makes your healthcare decisions in the event that you're incapacitated or you get a disability. And there's a joke that lawyers make that you get the mean kid to do the power of your property so they can make all the good financial decisions, and the nice one to keep you on life support. So. And then a HIPAA authorization permits you to name individuals that you want to be able to have access to your healthcare records if you were to be in a hospital. So you're going to want to, sadly, think about all these things just so it's easy for your family. And so, how do you get started doing any of this? So number one is I would contact an attorney who has estate planning as the primary or one of their main areas of practice. And the reason for this is, yes, we all go to law school, we all have classes on wills and trusts and etc. But there's a lot that you learn in internships and on the job that are kind of surface level in law school. So even though an attorney a general attorney can help you to an extent, you're going to want to get one that, you know, is used to dealing with that area and going to court for that issue. Because, you know, yeah, any attorney could probably tell you the difference between a will and a trust, but if they don't practice estate planning, they're not going to know about that 9-month window, or they're not going to know about, you know, etc. So, and then another thing that you're going to want to know is what information will you be asked to provide when you meet with an attorney. So, the first thing that you're going to need is just information about you, of course. Yes?
Kind of give the average cost for doing,
A trust?
is it dependent upon the total assets value or is
It is priced honestly based on the firm that you seek out, based on their expertise. There's not a lot of firms that charge you more for having more assets. It's really just the legacy of their firm, their reputation. I would say that an average will and all of these other ancillary documents altogether would be around $1,000 to $1,500 to get them all done. A trust is usually around $3,000 to $3,500. That is personal quotes from my firm. If you go to McAfee and Taft downtown, a trust is $10,000. So it just depends on where you go. And it doesn't mean that, you know, one is better than the other, but some people just feel more comfortable, you know, if you have the money and you want to spend it, you know, so. And so, yeah, you're going to want to just provide information about yourself, age, birth date, your residential information, your kids, their birthdays, your siblings, your parents, what assets you have, the value of them, etc. Just, you know, my colleague, she makes a joke that when she meets with a client, she says she's going to ask him everything short of his blood type, so get ready. So. And so we also want to know information about your property. So this is actually a checklist that we use at my firm, and it just kind of makes it easier when we're asking you. We just go through and we circle, we write the number, we make notes, you know. Do you own real property, which is anything residential, homes, condos, apartments? Yes, no, how many? Do you have mineral interest, stocks, bonds, cars, bank accounts? Do you bank at Chase? So we ask that because if you're making a trust, Chase is unique in the fact that you cannot change a name on an account at Chase, because usually when you change an account name for a trust, you need to designate it in the name of the trust. At Chase, you have to close your account and reopen it. So if you have any automatic payments, you're going to want to find those. So do you have any life insurance policies, IRAs? Do you have any businesses, LLCs, S corporations, etc.? Yes. What'd you say? Jewelry? Oh yeah. Oh yeah. That's that would fall under real property. So yeah. But yeah, that's important. Okay, and then of course you're gonna want the information about the beneficiaries, which is the same thing that you would give about yourself, but you're also going to want to include what do you want to give them, how much, and do you want to disinherit them or not? Believe it or not, people get disinherited all the time. See it every day. Various reasons. Don't feel bad about it. You worked hard for your life. It's your stuff, you know. So, yeah, I see a lot of people just disinherit it. Yeah. Right.
Is it easy to have them back?
Yeah, just remake your will. Yeah. Very easy. Okay, and so I have some recommendations that are just kind of made from myself and from, you know, my firm and the things I've learned from them, just to kind of make everything easy. Is you're going to want to keep an original copy of the will in a waterproof, fireproof safe in your home. And the reason for that is whenever you open a probate, you're going to have to take that original document to the court clerk, whoever is the personal representative, executor, etc. So you're going to want to know where that is. So I recommend that everyone informs their loved ones where the original is located, because they're going to need to use it. I recommend, my parents are loving and open enough that I would give your loved ones a copy of your will. Tell them what's in it. Share with them. Talk about it. Who wants to waste $10,000 because people are fighting when you could have told them while you were alive? Yeah, I know that's not how a lot of people will do it, but I think it's a beautiful thing if you can just put it out there. And then another thing that I would include is stay organized. Along with your original will, make it easy on your family. Make it a one-stop shop. So get a big folder, binder in that safe. Put burial wishes, information on plots if your loved ones have already purchased them, their attorney information, banking account, password, subscriptions, anything that needs to be canceled, the electric bills, cable bills, anything that's going to need to be paid or stopped, and personal letters to your loved ones if you just desire to put them in there. That way you just open it and there everything is. You just go down the list. And you're not searching through a house trying to find things. And depending on your family, it can be difficult. I have a client whose father was a hoarder. And he told us that he got through a stack of one chair in the office, and it took him 2 weeks. So we have no idea where that original will is. It is, and no offense, but the older people are, the harder it is because they just tuck things everywhere, So you're going to want to ask, how often should you update your plan? You're going to want to update your plan first and foremost if there's anything that you want to change. Any major life changes that occur, you're going to want to update your plan. Someone gets married, divorced, kids born, kids adopted, you get a large purchase, you move your residence, you move states, anyone passes away, God forbid. And then otherwise, if you're just smooth sailing, you're going to want to review your own document each year just to give yourself an overview and check through, see if things are where you want it. And then you're going to want to meet with an attorney to do a substantial review every 3 to 5 years. And the reason for that is not so much because your wishes might change, the laws change all the time. And we want you to have the most up-to-date language in your documents. So, yes.
So if you already have a trust, you're saying that you should have it reviewed by an attorney. You said every
3 to 5 years.
5 years?
Mhm. And depending on the firm that you made the trust with, some people make the trust online. I would recommend that because trusts are very complicated compared to wills. They usually, or my firm, we send out a letter, like along with our Christmas cards. We send a letter if the client has a trust or a will with us. We say, hello, hope everything's good. Could you please, if any of the following have happened in the last year, please check the box and send it back, and we will give you a call and schedule with you. Has anyone passed? Anyone moved? Did you buy anything? And we kind of try to make it easier for them by sliding it in their face, so you guys don't have to think about it all the time.
So if the firm that you did all of your documentation but no longer exists,
Mm-hmm.
could I go to another firm
Mhm.
with the same documentation, or would I have to start?
No, you do not have to start over. Yeah, we will take that, and depending on what you want done, we will review it and make changes, or just go from there. It's actually kind of makes it easy for us because all the information's in one place. So I wouldn't let changing attorneys or firms dissuade you from getting your items reviewed. And so when you're hiring an estate planning attorney, what are some questions that you're going to want to ask? So the first one is, of course, is the attorney's primary focus on estate planning? Do they have that depth of knowledge of the minute details? Does the attorney have a formal updating and maintenance program? Does the attorney charge a flat fee or an hourly rate regarding estate planning? one's not really worse than the other. It's just that flat fees, I feel like it makes more sense after you sit down with the client and get all the information. It's just up to me to type it up, write it up, get it done. I know just about how long it would take. I would prefer to just charge a flat fee. That way, clients don't feel hooked into something that they're not going to be able to stop. However, the probate process generally becomes an hourly fee because one little thing goes wrong, and boy, it can take a very long time. The average probate process is 6 to 9 months if not a thing goes wrong. That's how long it takes. So I would just recommend, and also to convince you to utilize documents where you don't need to probate. Our firm does not take a probate for less than $5,000. So cheaper to just make a will or trust. Just saying. Cheaper to just do it. And then, does the attorney have knowledge of the tax implications regarding estate planning? A lot of attorneys don't. And it's not a terrible thing, not to throw shade. It's just that taxes are large, especially the bigger the value of your estate, the bigger the tax bracket. And you're going to want to know those rules and provisions. There's actually courses called, estate and gift taxation that you take in law school, or if you don't have the luxury of taking them in law school, you do things called CLEs, which is continuing legal education, because you're going to want to know that information to save your client as much money as possible. Just to give you a example, if you have a trust, to put your life insurance policy or a 401k in your trust, it's taxed at a 30% tax bracket. So basically, almost half of what you're putting in there is chunking out. So our firm generally does not list your trust as a beneficiary on a life insurance policy. Of course, laws are changing. They're actually changing that law right now. So we'll see what happens with that. But you're going to want to know tax information, or you're going to want your attorney to know. Yes. I'm sorry, no, I didn't want to scare you.
So we should not have our life insurance policy as the trust is a beneficiary of our life insurance policy?
Generally, no, but they're currently changing that law right now. So I would just contact an attorney and ask them what their preference is on that. So, sorry, no heart attacks, no heart attacks. And another thing you're going to want to do is, a lot of people don't do this, but I think it's a good idea. Just ask for horror stories. If they don't have any horror stories, then they may not know how to avoid them. In the short time I've been practicing, I've seen a lot of them. I've had a client that he made a will, he made a trust. He thought he put the house into the trust. He never funded the trust, which is something that basically you have to title the asset in the trust in order to bring the trust into existence. So he had paperwork, but the trust didn't exist. So there goes his house to probate. So you're just going to want to talk to attorneys, talk to friends, even just read online. There's a lot of material online that can kind of give you a short and sweet overview of the differences between trusts and wills and what you do and don't want to avoid. And then also you're going to ask yourself, can I see myself working closely with this person? You're not going to want to dislike or get bad vibes from the person that is, holding your livelihood in their hands. And it doesn't mean that, any professional attorney, that shouldn't matter, but people are people, and so you just want to feel the best. You wouldn't go to a doctor that doesn't listen to you, so why do that with an attorney? So that is all. And do you guys have any more questions? Also, I will be giving another presentation focusing on trusts, and it is a more personalized approach to distributing your assets. Questions? Yes.
I have a question
for the heirs? Like, is there an inheritance fee that needs to be paid? Like, once, say, if a deceased has a beneficiary on the account, like, once the heir gets the money from the account, like, do they have to pay anything?
Generally, no, they don't. Usually what you see is with gifts, which means they're considered gifts because you're still living. If I'm gifting you amounts of money or transferring funds, often you can run into tax consequences with that. So it's not really so much of a thing if you have a will or a trust in place. Yeah.
You might come this in the next one, but if you have a trust,
Mhm.
and then you have a moral will,
Mhm.
does that, will you still have to go to probate?
No,
You don't.
you do not. No.
What was the question?
If you have a trust and you have a pour-over will, do you have to go to probate? No. Basically, a pour-over will is a last will and testament it serves as a big bowl, a safe haven, where if you buy something towards the end of your life and you forget to tell your attorney, you forget to title in the name of the trust, the will pour that asset into the trust. So it automatically will be covered, which is something that you can only do if you go the trust route. Mhm.
I have a question from you too. What is the value of a dual power of attorney versus a simple power of attorney?
The value of a dual versus a simple, the value, like how much you,
I'm pretty sure she means durable.
oh, the value,
Is it a difference?
the difference between the durable and a simple. Yes, so the durable, basically, when you have a durable power of attorney, that survives death. So sometimes you'll execute a power of attorney when your loved one is still living because they've fallen ill and immediately you know you're going to have to start making decisions. At a certain point after they pass, that power of attorney no longer is in effect. And so if it's durable, you can continue making those decisions on your loved one's behalf.
So my grandmother passed in July, and I have a durable power of attorney for her.
Mm-hmm.
So I can still use that power of attorney to conduct her business.
Mm-hmm. Yeah. But is it medical or financial?
It
Financial.
was
All encompassing? Yes, you should be able to. Mm-hmm. Mm-hmm.
I think you have to couch that based on the state, because I had that in the state of Louisiana.
Oh yeah, state laws vary greatly. Actually, right now, a lot of attorneys are kind of annoyed because states have a statutory form as far as healthcare power of attorneys go, and we recently have gotten a statutory form that they pretty much copy and pasted from Texas. And there's even provisions on there that we can't even do in Oklahoma. They just gave it to us, and so. We're hoping that we'll see some better results, but if you have a good attorney, there's always a way to get exactly your wishes. One thing that our firm does is the statutory power of attorney form is 2 pages. Ours is 4. It covers a lot more things in depth. There's an area on the form for additional wishes. We attach our form as an addendum, so they're both in effect.
Suppose you want a name and you have trust, but you don't necessarily want a family member to be executive or trustee.
Oh yeah, you most definitely can. You usually, most people do because they want to pick whoever they trust. Usually your personal representative.
Want to eliminate vice.
Yes. You want to pick a person that you know is going to see your financial wishes through to the very end. And like I'll cover in my next module, that includes things from finances to caring for any minor children still in place, And don't worry if your trustee's like, oh, you had $5 million, I'm going wild. There's things in place that we can remove that trustee. If they go spending willy-nilly, they're out. So there's plenty of ways to make sure that you're comfortable with your documents. Yes.
If you hire an attorney to put together a will or a trust and you don't take care of having like the original, is that something that the firm would have available to family?
It depends on the firm's policy. Our firm, we retain records forever, usually in digital format. We don't typically keep the original paper copy. That's usually for the client's duties, but we do keep all of our documents that we make. And there are instances where the original is just nowhere to be found. You know, sadly, maybe your house burned down. You know, hopefully the person didn't pass away and the house burned down. You know, if it all goes one fell swoop, there's ways for you to have a copy and go to the court, and it's a longer process, but we can make it happen. And then there's some firms that don't keep records or forms at all. And that's more so rare. I see that more with benefit programs. Like when I was in law school, we had the Native American Wills Clinic where anyone with Native American blood could come and get a free will. And we told them we keep no records on file. So it all goes to them. So it just depends. Anything else?
Okay, so for like 401k,
Mhm.
I definitely should not have that listed. The trust does not need to be listed as a beneficiary for.
As of right now, we say no, but that is an exact law that the legislature is currently changing. So,
Okay, and that will impact the life insurance policies.
yes.
Okay. Okay, and then, okay, I have a question. In terms of, when you talk about who has copies of
Mhm.
those documents, if you have a financial advisor, do you recommend them also having a copy in addition to whatever attorney or law firm that you advise?
You can give a copy to whoever you want to, whoever you feel has your best interest at heart, whoever you don't mind knowing your personal information. I know a lot of people have financial advisors serve as trustees, and there's situations where, you know, sadly, if someone has no remaining family and they don't, you know, trust any of their friends, you can have a financial institution be your trustee. I'm proud of you guys. You got less questions than last time. You guys are remembering some stuff.
All right, well, we want to thank Jordan for that wonderful presentation that you just gave. We got a lot of really good information, so yeah. All right, so that concludes our presentation. Thank you for joining us in person and online. We will have a follow-up presentation, as Jordan mentioned, around trust, and that will be Thursday, July 21st. And so we look forward to everyone joining us again at that time. Thank you again online and in person. Have a great evening.
Which one?